I think the last week of classes were upstairs. If you had classes in that room on the fourth floor.
That's a copy of the building condition.
Yeah. So the last week of classes overlaps with the JD program starting because the JD starts in August. So we're in the fourth year for the last week.
Oh, better than the basement.
They used to have classes downtown at Dundas.
Oh.
That was really good.
That was nice.
Wednesdays were awesome. I like Wednesdays. The other days suck.
Any day was good with leftovers.
Any day is good with free food.
I think there's a limit to that. So I sent an email out asking you to take a look at a decision called Moreland Jones versus Terry. If you did a search on Canley, you'll see another Moreland Jones case. The Moreland Joneses, in this case, got divorced. Later on, by 2018, they were in litigation for divorce. So the Moreland Joneses were not happy people for a few years. Maybe things started with their neighbors, the Terracks. What happened here? Why were the two antagonistic towards each other?
They didn't like each other.
Should we elaborate? Why? Why are we looking at this in the context of privacy?
I guess basically just like, I think it's set up on a security camera, pointing towards basically the defendant's home, and then went back and forth from there.
Yeah, so the Terrack, was it the Terrack?
It was there for the defendant.
Who had the video cameras?
Plaintiff, more
Okay, Moreland Jones' position, their security cameras, so they captured comings and goings of the Terracks. And didn't the Terracks do something with their dog, like fertilize the lawn?
The premise of the case was basically this pooping scoop.
Yeah.
So they pretty much took like their dog's poop and put it into the plaintiff's garbage.
Yeah. So there is an antagonistic relationship between the two. If you read the decision, you get the sense that the Justice Morgan was not very happy with either party. But I posed the question, did the Terracks lawyer miss something in terms of privacy? Was there an available argument regarding privacy?
I think there is. The fact that the security camera found at their house and they are not focused on the plaintiff's house, I think over here there is an argument regarding privacy.
Yeah, I think, so, I don't know how many of you know EU law, but there's a famous case from the European Court of Human Rights, I think it was, coming out of Sweden, that basically had these facts. There's one from Sweden, one from the Czech Republic, where basically it was, I think the Czech Republic one was the camera. They positioned the camera so they captured everything happening across the street and so on. The argument here is what? If you were the lawyer for terror, how would you articulate this argument? So the premise of why I'm doing, of my question and why I'm looking at this is, I mentioned before that privacy, I don't think is very well understood right now. But we're sort of being forced to think through privacy because of innovations in information technology in particular. So social media, surveillance. So if you go to London, for example, London, England, you'll be captured on video like numerous times because there's something called closed circuit TV or CCTV everywhere, and that came out of the Irish Republican Army bombing London. So they put up all these cameras. And that was back in the 80s, but now the argument is, well, are you capturing too much? So if you have a video camera that you say is for security purposes, but you position it in a way that captures your neighbors, what argument does your neighbors have in terms of privacy?
Not so they have a reasonable expectation of privacy in their lives.
Okay, so how, elaborate on that. What is arguably violating their reasonable expectation of privacy?
Because they are not in a public place, they're like the place.
But arguably they are. Once you leave the door, you're home. Are you not in a public place?
I think at some point you have the like front yard and like, it's not about the door, like they're going and coming and they even private life thing.
Okay.
It must be captured. In
Right.
the
So it captures when people are coming and going, who comes to visit them. On top of that, depending on how the camera is positioned, it may capture things happening inside the home, if the the drapes or blinds are open. And what's the difficulty with that? What are we looking at in terms of a potential violation? Why is that something that we would argue is a violation of privacy?
Well, it goes down to old cases of treating phone,
Yeah.
kind of, similar to that. But the biggest concern I have is from the Jones and the C
Yep.
file. One of the elements is that you really have to prove privacy being breached. And the problem is if you're in the front yard, in front of your house, what are your expectations of the privacy being? Not to be looked upon 24/7, being outside? It's a hard argument to make.
So here we're kind of getting into, so leaving Moreland Jones a bit behind, that I'm using this as an introduction to the idea that there's something that I think you're coming into practice in Canada at a time that the concept of privacy is evolving. And I would suggest that in the future, this is going to develop further. So Dayon brings up the point about Jones and Tasiki. What was it? You have to improve privacy?
Yes, it was, it was a story about two co-workers,
No, I remember the case. Well, your argument was,
privacy. Because in C, it was 100%, intrusion upon secluded
Right.
information. That a bank,
but then you talked about once you go outside.
once you go outside, I mean, where are the boundaries? You cannot have aura going around us saying this is a protected area and you cannot film, you cannot look at me. That's something that the law would protect.
Right.
Besides, if it comes to litigation, we all know that in litigious situations, the surveillance is the tool. In the cases where, litigants want to prove something about the plaintiff not being, accepted or confirmed by the plaintiff in terms of abilities to do certain things, conduct certain activities, it's a common tool, it's being used, like the old Spy by Google, right? By Google Maps. So the issue of privacy is very hard to define.
Okay. So this is, Dayon puts forward what I would say is a common argument against going further with a concept of privacy that grounds an action in tort, whatever that action might be, whether it's intrusion upon seclusion or something else. That it's just too difficult to define privacy. And once you stand outside, basically you waive your privacy rights. Yeah.
I'm going to say too, coming back to the Terry case as well, I feel like in the judgment, one aspect that was overlooked was basically when the judge said, we pretty much can't bring reward damages for just looking at a pretty house. And
Yeah.
and it comes back to like, what is the spectrum?
Well, if I may add one thing, I mean, for me, keeping cameras, at your house for the reason of just causing a disturbance is a pure nuisance.
Yeah.
It was an action in nuisance, and I'm not so sure why it hasn't been pursued, or what was the argument. Obviously just go bits and pieces.
Well, I think the judge basically said you're both jerks and you
I know.
antagonize each other.
Yeah, but there is a jerk that is really starting it off by way of saying, I'm gonna keep you 24/7, 365 on my camera. So
Yeah.
there's something wrong with that guy.
But as a premise in tort, if you react in malice, you basically lose your right to bring a tort action. So arguably here, both parties acted with at least a certain level of malice that undercut, but in the court's opinion, basically eliminated their right to bring an action against each other.
Yeah, I was gonna say that's exactly what the judge pretty much said this is pretty much adverse of the plaintiff's case, but it should have taken the level of hearing fee.
Yeah. So, I want to get into this point that Dayon had brought up. I apologize if I overstate it, but is it worth having an action in privacy or pursuing a tort action in privacy? I think it is underlying this question because once you leave your home, once you go on the internet, you have waived privacy.
It depends on the place that you are, like, if you are, like, within your, like, personal boundaries, like the home or your personal car, like, all those places require limitation of privacy in there. But
Right.
whenever you are in a mall or public place or whatever, like, for sure, you might be captured with surveillance cameras. So it depends on the place where you are in.
Edward,
Yeah, so I think also it depends on the information or the thing that you are collecting about the person and the way you are using. For example, even if you are in a public place, let's say for a school, yeah, and there was like a case for a teacher who was like taking videos of his students, yeah, and use it for like sexual purposes. So that's voyeurism. So it's also like depends on what you're gonna do with those.
I'll just, I want to steer it away from voyeurism just because it gets into a bit more criminal law,
Yeah.
I would say. But the idea of Everett's point, what data, if I could put it that way, are you collecting? What information is being collected? And Dayon, I haven't forgotten, Dayon brought up Google. Google monitors us all the time, but that doesn't make it right. I guess it is one of the things, and I think Google and Facebook have been able to get away with a fair bit at this point because everything's new. And unfortunately, I think the law and particularly governments, have sort of missed the opening, and now they're trying to catch up. So they're trying to pick up the really nasty stuff. Like in the paper I gave you, I talked about revenge porn. And revenge porn, having an action for that, you're familiar with the term, right? That there's an action that can be brought for that, and there's a criminal action charge that can be brought. But that doesn't get at the idea of privacy in a broader sense. We're just sort of picking out these select instances and saying, well, that's just too far. I think part of the question we have to really ask is, well, why are things too far? What is being collected? To what purposes is that data being used?
And that was my point, that because technological breakthroughs have been like too quick, so the law has been left behind.
Mm-hmm.
Because they're so, like Facebook wasn't as big as 10 years before.
Yeah.
So everything is becoming so quick and law is not developing as quickly, so that's why we have this big gap. And that with acknowledging only specific instances of violation of privacy, there will always be new cases that maybe they are not captured in previous instances, and then we will have actions that we can clearly see with an intuition that they are wrong, but we haven't established a general, let's say, principle or, yes, the reason behind all.
A philosophy
Yes.
or parameters.
Because we haven't, I think, taken as seriously, we've taken seriously like a physical property, that let's say the dignity of a person, the data, and the data as a property, we haven't taken that.
Information.
Yes, information.
And so we have these different classifications of privacy. We can have informational privacy. Usually we talk about physical privacy, and going back, and not to pick on Dayon, just because he didn't brought us into the topic. Dayon focus on the physical. Once you leave your home. But privacy isn't only about leaving your home. You could be a shut-in and go on the internet and have information privacy rights, data protection rights, and then Constantino talks about dignity. And I'd say, as you go through your careers, I would advise you to look at the EU, the European Union, on this point. And to give some context about how important the EU law has been in this area, there's federal legislation in Canada called PIDA, the Personal Information
Protection Act. Protection Act.
Yeah, well, Personal Information Protection and Electronic Documents Act. And it was brought in solely because the EU brought in what is now called the 95 Directive in 1995 regarding trade. And the EU said, we will not trade with any third-party country meaning a non-EU member state, unless that country has data protection legislation in place. And now there's a successor to the 95 regulation that came into effect last year, May of 2018, called the General Data Protection Regulation, the GDPR. And why I bring up the EU is the EU really seems to be leading the way in terms of regulating particularly information privacy, data privacy. But the cases coming out of the EU, and you can tell me, I wonder if it's because of the civil law influence, there seems to be a better understanding of dignity than in the common law. Dignity, in terms of privacy in the common law, is still a vague area. Just as in the paper I talked about reputation. I don't think in Canada, whether you're talking about defamation or privacy, I don't think the courts have sufficiently articulated what is meant by reputation. And arguably, Constantina's point about dignity underlies that. You'll see that word used, but in the common law, we don't have very good understanding of that, whereas, I don't know personally, but my sense from the European Court of Human Rights decisions is there's a lot more behind the civil law tradition in terms of dignity than we have with the common law. So this topic, I would say, is at this intersection. You'll hear phrases like black letter law, I think you've heard, or doctrinal, and then you'll hear a word like theory, which usually puts many people to sleep. And what I suggest to you is privacy, defamation, this idea of reputation or information privacy, whatever it may be, really is at the intersection of what we call black letter law and something a bit more philosophical. And I suggest that we're still at the point of articulating a philosophy behind what we mean by reputation and privacy. And we haven't even got to the point where we can have common law decisions or legislation that is overarching like a general data protection regulation. And to be clear, I'm not saying that GDPR is great. I think there are a lot of loopholes in it, for anybody that knows about the GDPR. But I think the EU is more advanced on that level than on this side of the world, for example.
Oh, well, I was just thinking about the North America in general. Obviously, talking about dignity and living in North America is something that cannot be reconciled at all, because here you're kind of checked wherever you go. You buy coffee, you go see a doctor, everyone is selling your data for money, and that's actually a legal business. As a matter of fact, people in North America are even more stupid. They're selling themselves using Facebook, and actually inviting everyone over to not just see their house outside, but just to see inside of that person's underwear.
Yeah.
You know, it's sick, it's kind of retarded.
It's odd.
It's retarded. It gives actually surveillance available to anyone. Well, I can tell you, I work for a personal injury firm.
Yeah.
And plaintiffs are actually giving 100% free surveillance to every claim because of the Facebook. They're posting pictures about picnics, enjoying life, blah, blah, blah. And unfortunately, the court said, you waive that, you're out there, and those things are relevant. So you have to fork out photos that you've been posting and, you know, collecting since before the accident and after the accident. How ridiculous it can get than that?
Well, yeah.
Like, you know, your waiver is now being used against you since you're using the app that is made for, you know, monkeys, by monkeys, and someone is making money out of it. You're stupid, but you live in North America, the most democratic society in the world. That's the end of the civilization.
I think it's a bit more nuanced than that. So people, I think one thing we have to look at is when people post on Facebook or Twitter and just leave everything open for public viewing. I would say that's different from someone, let's say, shares a comment or a photo with a few friends. Like tags a few friends and says, look at this, or look at what I'm doing today. I think there's a big gap between those.
But you can beat that, because this is how it goes. This is what the typical investigator would do.
Yeah.
He would befriend a friend of a friend of a friend, then actually enter through the back door and actually became a friend of yours on any of those social media platforms. Because this is where you're opening the floodgate and you cannot stop it.
But yeah, but it's premised on the idea that you're going to friend everyone that sends you a request. If we use a Facebook analogy, I'm not that friendly.
I don't, you know what, I don't have, I realized from the get-go
Yeah.
that this is the biggest trap that anyone can do for himself or herself.
I think Twitter's bigger.
I don't know, I don't
think
use
Twitter,
this.
because Twitter can be searchable through a random internet search, whereas theoretically at least with Facebook, you have more privacy settings.
Okay, my point is, this is a society of a big brother, actually. And if people don't realize that we can talk about protection of privacy, maybe when it comes to government and using data, that may be a point of freedom.
Right.
But everything else is out for sale. And people are actually happy to join that movement. I don't believe that it makes sense to anyone, and this is just me old-fashioned guy. But I can see how it transpires later on when it comes to litigation. Then you're just bending over a barrel and
Yeah.
you're forking out everything from your life that maybe your priest doesn't know.
Yeah, and so personal injury, I think, is an area that has a long history of surveillance and people being caught out. Somebody that says, I broke my back, and all of a sudden they're building a deck at home.
Well,
That's,
they're good on bad days, right?
yeah, so in personal injury, they're looking at fraud in terms of insurance claims. But I guess part of it, I wouldn't want to overgeneralize, or I think we're in danger of maybe overgeneralizing the point. Because explain that.
For like Facebook or Twitter, this kind of platforms, to me they are not platforms that take away your right to be private. They giving you the right to be public if you choose so. So if you want to get on public and everybody wants to
Yeah.
see as to what you're doing, then you have the right to do that. But you still maintain the right to be private if you so choose to be. In regards to the case, I think the big problem there starts with the recording. Because it's like everything, as long as it will be intercepted and observed by your eye, it's fine. Like no one can see in a public place why are you looking at me, and that's your scary.
Yeah.
But once you are entering into the recording, and that can create the possibility that you can use it later on for whatever purpose. But that is the gray area that kind of needs to be regulated, and I think but it is regulated, it's not that, but it's the area of concern, that the problem.
So let me come back to that in 1 minute. The point that I forgot to mention is, even though this data is collected by, say, Google or private sector entities, they can only trade it based on the idea that it's anonymized. Now, is it anonymized? I think is a legitimate question, or how well is it anonymized? So, for example, Facebook, that's how it makes a fair bit of money, by aggregating data and selling that on, so that the purchasers shouldn't be able to sort of reverse engineer who these people are. But there's a question as to how effective that is. So the area, I think, is a bit more complicated. Maybe than we give it credit for. Spartak's point about the permanence, I think is something that, or is something that I hope we will get to. Because everything seems to change once you have something written down or recorded. And I found that very interesting. I first saw it with employment cases, because there were all these people who would post how much they hate their job and their managers on Facebook, and then they no longer had a job. And their argument is, well, I was just conversing with someone. And the modern idea of conversing through Facebook walls or Twitter exchanges, whatever, is equivalent to the older form of going to a bar and having a drink and doing pretty much the same thing, complaining about your job. The difference being, once you write it down, the law comes in. That's the entry point for the law. And I bring this up because I think that's traced back to defamation. Defamation has been around for a long time, hundreds of years. And it really got ratcheted up when the printing press came into effect. So initially it was slander. Slander is a spoken version, libel the written. Why would it be slander in the Middle Ages of England? Well, because everybody's illiterate. Nobody can write. So you don't have libel cases. So slander was more important because that was the way people communicated. Sorry?
Witchcraft? Oh, hunt. Witchcraft. Hunt can be considered as the biggest slander case.
Yeah. So, yeah. So with slander, you just had to prove somebody spoke. But then with the printing press, things changed. But at that transition period, why I mentioned that transition period is because I think we are currently in one now. Moving from predominantly an oral tradition to a written tradition. A tradition where information is shared not orally, like Homer's Odyssey or Iliad, is now written down and can be dispersed amongst a number of people, unlimited numbers. The courts in England saw that as more of a problem than the spoken word. And so when we fast forward to today, and I put something on Facebook that my employer doesn't like, they don't sue me for defamation. They terminate my contract pursuant to the employment contract. But my argument is, this seems to be the legacy of that decision in the Middle Ages to look at the written form as more pernicious, more problematic than the spoken form. And the knock-on effect is, anytime you have a permanent rendition of a conversation, which arguably chatting through Facebook walls provides a transcript of a conversation, that's where the law enters in. So it's not, it's interesting that with defamation you have to have published it. Right? The three-part criteria. It's about the person, it's been published, and it's defamatory. The publication part is satisfied with a Facebook post. But if for a non-lawyer who is just complaining about his or her job, they just see this as a conversation. So people are kind of, have been unwittingly walking into this kind of a scenario that the law has really tightly regulated, but they just think they're carrying on from their normal lives, like they did at Starbucks, talking to each other or at the bar. So I think this is an important transition to keep in mind, and now we're moving from an analog to a predominantly digital era, where everything is captured in some sort of data form that can be shared and dispersed. And there are issues that come with that, and I think one of them is this idea of, or a wider idea of privacy. Not just your physical privacy, not being surveyed all the time, but your informational privacy, and then that even more troubling topic of dignity. whatever that may be. Tell
Yeah, I have a question regarding the last point, like you said that once the share anything on the Facebook, it's kind of defamation, but isn't it as to my understanding, the exact definition of the defamation is like to publish something or like information about somebody else, not about yourself, that,
Right, but if you're saying, I don't like, this person is a pedophile, to use an outrageous example.
no, what
Isn't
I'm
that-
saying, back for the example that you gave, that I don't like myself.
Yeah.
For example, disaster, whatever.
Yeah.
So this is my personal information. I don't think that it's related to the defamation.
But I wasn't saying that. So people are losing their jobs because of the permanence. So what you used to say in a bar, my manager is a pedophile, you put it up on Facebook, now you're fired. Because there's evidence. And what I'm saying is that the permanence of the record, I think how we treat the written form more seriously than the spoken form, because arguably what's the difference? If you tell other people my manager is a pedophile, or you post it on Facebook, you're still communicating the same point. But the law has regulated the written form, and that was the point I was making.
Shouldn't it be different if my post is public to anyone or only similar friends?
You would think so, but like, try doing it in the UK. You get fired for anything there. Like, it's really odd that they've heard of the European Convention of Human Rights in the UK, but I think it's part of the reason they're leaving the EU.
Because they were bound.
Pardon?
They were bound by the European Convention of Human Rights. Yeah,
They didn't like that term.
but they were.
Yeah, legally they should have been, but what it came down to, so one case, just as an example from the UK, a gentleman named Smith, oddly enough, he doesn't post on his Facebook where he works or anything like that. There's no identification linking him to his workplace. But he puts on his Facebook page, I'm against gay marriage. And his employer doesn't terminate him because he's been there for 20 years, so they just demote him. And the problem I have with that is, how does the workplace get involved in that? I'm not expressing a personal view on same-sex marriage. My point is, shouldn't that guy have the right to say that? You know, Voltaire's famous saying, I don't like what you say, but I will defend your right to say it to the death. That's what I don't understand. So I use that case as an example in the UK where in a land that is supposed to be democratic, there seems to be a tremendous limitation once you walk into a workplace.
So you don't have the private life.
Yeah.
There's no.
So that's why I say in the UK it's very different.
Basically, you cannot have
It's one thing to not express an opinion as when you're working in a company, but
Yes.
But this was at home, like,
Yes.
that's why I was saying there's nothing linking him to his employer. And they still allowed the employer to demote him, which in England is a charitable thing. You know, I only demoted him.
And they allowed it, and it was okay?
Sorry?
It was okay in the
Yeah.
case?
Yeah. So that's why I say it's very different, whereas in Canada.
And what
not-
kind of field he was? Was he an HR or?
No, it was private sector. I forget what it was.
I mean, I can imagine in certain, maybe in the private sector, or
But
maybe
he was
in,
anonymous.
in certain areas of work. he
Well, I
might-
think if he worked for gay rights, there'd be a
Yeah.
problem.
Yes, yes.
But I infer he wasn't. So I would say that there's a tenuous link that would allow an employer to terminate for that. Certainly the guy Smith rules himself out of certain things, like as I said, LGBTQ advocacy. He's not going to be able to work there, but he should still have a right to say that.
But now there is a case here which is fascinating. There was a very critical somebody who went to a private
Okay.
and You heard
No.
about this case? I should tell the name. Basically, it's a fellow, looks like a 50-year-old fellow, obviously very Catholic, and he was giving the flyers for the stand buyers, to whoever in the street, in the week of the pride, which was, I don't know, quotations from the Bible against people.
Yeah.
Right? And basically now he is in court. And
For
he's
what?
for human rights tribunal, and he had to stop working and move to Toronto because he has to spend so much time and energy to defend himself. Now they are collecting money for his defense. He has to have a lawyer, otherwise he's
The
self-represented.
Human Rights Tribunal would be different.
Yeah, but the point again, I mean,
If
did he
we're
do
talking
any
about-
violent? He didn't do anything violent. He went to the
No,
street,
but
which is a
the-
public, you know?
See, I don't know the case. The thing would be, it's a different threshold for the Human Rights Tribunal than a court or court action. Now, if the argument was that he was disseminating hate or inciting violence, that could be,
Didn't look like.
that
I
could
don't
be a
know, I
reason.
don't know the details so much.
Yeah.
Obviously, what I got was the pro document, something which was very.
Yeah, but
But
what,
still.
all I'm saying is, if it was brought to the Human Rights Tribunal, the argument could have been that this was inciting violence or whatever the case may be. I'm not pronouncing on the
No, apparently not.
success of that.
Apparently, it was not even, he didn't even say it's my opinion. He just said quotations, you know, like, you shouldn't do that, it's not good for human, I don't know. I mean, explicitly they said there was no violence, there was, I mean.
Well, there have been, you've probably studied it in constitutional law. There are famous cases about
Yes.
Holocaust law.
Yeah, but that's a difference. But anyway, I'm just saying, it's again the same thing, that you cannot even have opinion. I mean, I'm not talking about it, you
Yeah.
cannot express it, not in the work surrounding, not in the street, not in,
He didn't share it in a Facebook page, he
Yeah.
was distributing this on the streets.
on the street.
So who knows what he was distributing first? And I think the difference between your case that you are saying and this one, it's a Facebook, it's a private page, and he did it just for his profile.
Yeah, I'm not saying he's right, or I'm not any opinion, I don't know the details, but it's just, I'm just troubled more and more time.
Yeah.
I feel that you cannot have your opinion.
But an important distinction to underscore here is you're referring to a Human Rights Tribunal case. And that's a different threshold from what we're talking about here. So if we're talking about privacy and
I'm sorry for it.
No. I mention it more for the reason of, you, as you go through any assignment, you can kind of veer off. And part of the challenge is sort of staying on topic. And I just want to say this to underscore that was all.
Yeah, Barbara, I have a question. You were mentioning that comment that he was
Yeah.
posting on Facebook, that was kind of similar to what we used to do at the bar and
Yeah.
people do. And then but I think it's quite different because when you post something on Facebook, there is an option that people can share it and distribute to the
Yeah.
bigger audience.
That, I think, brings up a different issue, though.
Mhm.
If you have selected a group, let's say to share certain information, let's call them your close friends, just to categorize it, and they share it onwards, have they breached what we might loosely call your confidence in doing so? Like, this is where I think we get into layers.
No, I think if you choose like your close friends, if they share your like post, so nobody can see it because you already restrict the post from.
Yeah, I wasn't
everybody.
limiting it to Facebook, I was talking about generally. If you share something with close friends, then you talk to them about more intimate or personal things, and they share it on, is that something that breaches a confidence? So one example, in Dalhousie, you might have heard, Dalhousie Dental School. What was it? The male students ranked, the female students, I think it was, in terms of attractiveness. but did it in a very crude way. Like I said, I don't want to go into the details of that, but how it was released was one of the people in that group sent it on to the university administration. Now that, I don't think we'd have a problem with somebody sharing that, because arguably there are other interests at stake there, safety, for example. So I'm not talking about those scenarios, I'm talking about, in Byra's example, where you share personal opinions that then get pushed on somehow and circle back to, say, an employer. When we talk about employment. Does that create another issue? And I think that's an open question.
I was gonna say, in terms of viability, what about like public office positions as well? Because often sometimes you'll see with like politicians, for instance, like I have some friends from law school who went to that political field, legal professional field, and eventually they started doing tweets and images that we used to have up. And I know, for instance, like in Alberta, there was quite a few, there was like, I think it was like an NDP candidate who posted certain things, I think, in regards to like the LGBT community or something referring to drugs and narcotics, and eventually just came back to be used against them. So in terms of like public figures, because I think for them to, when they can do the higher threshold, in the sense of because they are a public figure, so in terms of like anything that makes definition,
Yeah.
it's treated as accountability.
Well, as a general concept, when you're looking at libel or privacy, if you're a public figure, there seems to be kind of a different set of rules for you. Now, the argument is, if you're a public figure, do you have more rules for you? Like, do you have more financial weight that you can sue everyone that does anything that you don't like? So that what's called a chilling effect. But generally speaking, if you're running for public office as a public figure, you're sort of a lot more wide open on those things. So I'd opened up the time, as I said, after the break, I would talk about duty of care for negligence. So I left this time, as I did with unconscionability, for a discussion that relates to the essay. Not that I'm going to itemize what you should put in the essay or anything. To me, this is a lot more organic. You take your perspective. But the question I posed is, how viable is Jones versus Cassidy, or however you pronounce it? You know, is it a useful action? So going back to Dayan's point, Dayan mentioned this is actually quite narrow. I think if I can speak for him, he was saying, well, this is pretty straightforward. This is banking information that somebody intruded upon. So the question then is, well, does this provide an opening for him?
I was gonna say, so back when we were talking about pretty much like development, and especially in this particular tort category, one of the impediments I would say is because when you're dealing with like charter, you're basically charter rights and privacy, basically how you can't be used in civil cases. So in terms of like CD, I think where it is in terms of just like private torts, I think that's where it is, it's truly organic, and it's going to just kind of just develop from there moving forward, I think.
Well, this is a complicating factor though. Hill versus Church of Scientology, the defamation case says, the charter is not directly applicable to private sector instances, but charter values inform private law. And the question is, what does that mean? Sort of abstractly, I think what they're saying is, if we have freedom of expression, where the government can't curb your freedom of expression, that concept is important even in the private setting. So in a private law setting, I think that's what they're saying. There's a question about it, and as I say in the piece I gave you, we don't have an explicit recognition for privacy in the charter. We have section 8, which is search and seizure, but that's more about criminal law. That's not about private citizens with each other. That's basically the tort domain, and that's what I'm focusing on here with Jones. Mr. Justice Sharp thought he was advancing privacy law in Canada. So as some background, Mr. Justice Sharp did his PhD at Oxford, and he still teaches there, civil procedure. And he was dean of the U of T Law School before he was put on the bench. So he has an academic background. So the article from 1960 that he cites by William Prosser called Privacy in the California Law Review is something that he had clearly thought about. So here you have an example I talked about before where you're bringing the doctrinal law, the black letter law, and some sort of deeper understanding of the subject matter, what I loosely call philosophy, let's say. So Sharp thought he was pushing things forward and in a discrete manner. But it raises further questions like, has Jones put Prosser's article, his 4 torts, into Canadian law? Or is it Ontario law alone? Where are we at with this idea of intrusion upon seclusion? And then, can we even say anything about privacy? And I think the point is worth reiterating. Privacy first came to our attention in 1890, when Warren and Brandis wrote their article, Privacy, in the Harvard Law Review, railing against cameras. I forget which author, but the press had shown up at his daughter's wedding and took photographs, and he was incensed. Because to him, you're capturing private moments for distribution to an unlimited number of people. And I don't know if now in 2019 we've really moved much further from sort of complaining about it in terms of the law. Certainly Mr. Justice Sharp thought he was pushing things along with Jones. But as I asked, has he? How viable is Jones? How have subsequent cases looked upon Jones? So I put that out for you. If you want to take up a bit more, you have a bit of time to do so.
Question for you, Mr. Condon. So how is the prospect of the toward intrusion upon seclusion looks at this age, where people actually gave up so much of their privacy for security?
So what are the prospects of privacy?
Yeah, I mean, like when it comes to government, then charter rights or charter values are not something that you can easily go to court and win about. The courts are really tough when it comes to charter rights. However, there is a regulation saying that you're supposed to strip for boarding the plane. You'll be readily doing that, and there's not going to be an issue about that.
Yeah.
So you have a growing, actually very strong force that goes the opposite way, where people are actually waiving the privacy, not just because of the regulations, but because of the overall feeling of insecurity and fear that is overly dominant in this society, especially in this century.
So,
for example, like in El Paso, yesterday, or, you know, what, 40 people killed? So I bet that everyone here would say, well, why wouldn't you put some better security measures so nobody can enter with a gun? And I bet all of us would vote for it immediately because it's ridiculous that you go to Walmart with kids to buy school supplies and get killed.
Yeah, well, I don't want to go too far down that route, but I would draw your attention to the debates that occurred after 9/11 in the US. I don't think there was necessarily uniform opinion around what transpired in terms of the law afterwards, because largely it was changes were premised on we need to secure ourselves. And there were other considerations, let's say, that were voiced at the time. I think something else that caught my attention in what you asked, though, is it too late? And what I distinguish is, even if we look back at when the charter was brought into force, the world has changed remarkably. But think about what the charter was doing. The charter was doing the same thing that a lot of constitutions did if we go back to Magna Carta. That was to curb the power of the state pertaining to the citizens within it. But I would suggest that within the life of the charter, the question at least has been raised, are governments the ones we should only be concerned about? Because we have multinational companies that have more power, not just power in terms of influence, but financial power that rivals many countries. And I don't think even the charter is the latest one for our purposes. Constitutions weren't developed with that in mind. It was always with a singular force in mind, the state. But what we have now with information technology is, what if the state has been supplanted or arguably has abdicated its role to a private entity? What does the law say about that? And I think we're still sort of looking for the answer. Yeah.
And there is another argument about security and privacy, is the commodification of safety and privacy.
Yeah.
So first they took it away and then made this demand of being secure, or that's why we're going and buying cameras. So we're believing it was because they are bombarding us with this danger, saying that it is dangerous, you have to buy cameras, you have to buy all the security stuff to make your house safe. So, and then, because, yeah, I sound like very liberal now, but there is, so there is no land, so they already shared that, so they commodified, that's the word? Commodified security. So that's one of the arguments against this securitization.
Yeah.
And I guess that makes sense.
Well, everything's a balance. That's the thing, and drawing the line. If you think back to the contract cases we looked at, many of you disagreed with some decision at some point, but the courts made a decision. They thought the balance was at that point, and I refer to that to illustrate that a balance is so hard to find that could be broadly acceptable. In security, certainly it is one of the preeminent ones. that we're struggling with. But I would be careful about the security aspect with the privacy essay. Just because I think you can go down a different route that maybe is different from tort. Unless you're looking at security as in how secure my data is or something like that. But security in terms of terrorism and things like that, I think would be, right now at least, I can't think of how it could be directly related to the essay.
That was just an answer.
No. Yeah, I'm not saying in response to you, I'm just saying in general, because certainly security is on everyone's mind. You know, we all probably went across CNN at some point over the long weekend. And it's hard to get away from the news. So,
Because I think because we want to be secure, it's one of the reasons why maybe people, there is no conception, public opinion about how much privacy we want.
well, and that's why I thought it was interesting where Dayon started us. Is it worth even pursuing because the proverbial horses have left and now we're trying to close the barn door to keep them in. So it's too late. Personally, I don't subscribe to that. I think that there's more to be discussed than that argument would put forward, but I appreciate what it's saying. And that is basically, we're trying to redo everything at such a late time. What I say is, aren't we at the beginning of a new era? The movement from an analog time to a digital era. And as you know, being lawyers from your home jurisdictions, once a precedent is set, it's very hard to disturb that precedent. So I think arguably right now, we are in the midst of that precedent-setting time. So your work feeds into this.
I noticed most of the states of the U.S., they are codified procedures for privacy torts, including California, etc. Canada has moved to a case law, at least one of them, which is the intrusion of seclusion. However, we seem to have quite a pullback with the case Merrifield versus Canada, where the lower court had ruled for tort of harassment, which is the second of Prosner's proposition, and it said that there is no tort in Canada on harassment.
What level was the court?
Sorry?
What level was the
It was the appeal court, which has overruled the lower court. The case is Merrifield versus Canada, and said the time has not arrived for this tort in Canada.
Yeah.
So I'm beginning to wonder whether we are tugging and pushing back at the same time, pulling and pushing.
Well, I see that as an expression of what I was just saying. Where the balance is, or whether this is the time, is a matter of opinion, and there's not consensus on that. So I gave you a reference in the paper that I gave you, that a lower court decision said, don't come to me talking about Jones and Basigi, I'm waiting for the Supreme Court. Yeah, and like arguably, what right does a lower court have to say, don't come to me with an Ontario Court of Appeal decision? If it was an Ontario trial level court. That, to me, just sort of emphasizes how wide the opinions are. But I don't think this is the only area that there is a broad range of opinions. I suggest we saw that with good faith. Cases that came after Bazin didn't necessarily accept what the Supreme Court was doing in Bazin. The fortunate thing we have is, as I told you, we have the Supreme Court hearing 2 decisions that deal with good faith within the next year or so. But we don't have anything in terms of privacy. Arguably, that's what we would need. A Supreme Court decision talking about this, being a landmark decision. But I bet before that happens, or when it happens, it will pull from the UK and the EU. And it might pull from the US, but the US is a very different system when it comes to free speech and privacy. I think it's important to keep that in mind, because what's the standard in the US for free speech, for defamation? Basically, at least for public figures, you have to prove malice. If somebody intended to defame you, which is a very high threshold. Why is that? Because in 1964, the US Supreme Court in Sullivan versus New York Times set out the precedent that has been followed, and what has come as a result of that is a smaller form of privacy, because privacy has been seen in opposition to free speech. If you keep something private, you're not letting it come out. The UK, Canada, Australia, New Zealand all went through decisions around the turn of the 21st century that said we're not going to follow the Sullivan standard. So I suggest that that is more likely the fit than the US model, because of that very important distinction in terms of free speech and defamation.
So you would see Jones more of the abrasion rather than the platform, compared to, say, Merrifield. Merrifield saying that there is no authority, there is no case law, there is no legislation, and there is no tort of at least harassment, which is one of the four.
Yeah, well, harassment since the 1980s with a Supreme Court decision called Viduria,
Yeah.
the court has said there is no tort of harassment. But if we're talking about privacy,
Well, the harassment was suggested under the privacy platform rather than, I know the Viduria
right,
case.
but the difficulty that they were running into in Merrifield was they were trying to do what's called an end run around the precedent of Viduria.
Right.
And the court was saying no to that.
Strange
So
enough.
you see that with privacy. Some people will, in the UK especially, some people try to reclassify a libel action as a privacy action because they don't think they'll be successful as a libel.
Jones seemed to have justified its timing on the basis of the incremental argument,
Yeah.
and also on the argument of the incremental argument and what was the other one? However, exactly that statement has been made in Merrifield, that there is no, incremental and crying out for remedy.
Yeah,
And both of
basically
those have been
sharp up
rejected
times
by the Supreme Court in Viduria, and also,
But Viduria was about harassment, a tort of harassment.
Yeah.
The reason the court ruled that way, going back to Zita's point, is that I made with the Human Rights Tribunal, is the Supreme Court said you have a separate regime for this.
right.
So we're not going to duplicate a regime. We're not going to create a common law action that supersedes basically a tribunal apparatus. So that was why they made that decision in Viduria.
Okay. So my question though is
Was Viduria
is
around
it-
the Senate College?
Yeah, I think it's in the tort textbook. I haven't, we weren't doing it because it was basically a very discrete point.
So my question is, given, is it in a state of where we've reached that incremental point in privacy? Is that the big question?
Well, I think that's part of what your essay would engage with. You certainly have Sharp saying, I think it is. But you have these other decisions that say, no, it isn't. I personally don't understand how you can say the time isn't now, just because I think we're in this situation because we have refrained from regulating or legislating in the area of privacy in a broader way. But I don't say that to tell you where to go in terms of an essay. I put it out there, more out there for discussion purposes. I think with information technology though, I don't think we can let it go any longer.
But that's precisely the point in Jones where the judge was cautioning about the floodgate effect, given the pervasiveness of this digital
But that's
transmission.
why he decided on a discrete action of intrusion upon seclusion. But what I said a bit ago was, if you recall, he cited Prosser's article that identified 4 privacy torts. And my question was, does Jones bring those other torts into Canadian law, or if not Canadian law, Ontario law? Where is it going, is my question. So if you, and I bet you will, have a privacy case in your practice, what would your response be? This is basically an opportunity to explore that idea in what I would say is a more friendly setting than doing it on the job. Did I miss somebody? Constantine, did you have your hand up? Did I miss? So what I'll do is, we usually take about a 20-minute break. I'll go until 10 to 8, in case people want to ask personal questions they didn't want to ask in front of everyone about the essay, since maybe it's jogged some questions. Ms. Donohue's ginger beer.
Snails.
A decomposing snail. So it was in the bottle. The bottle was a dark color. So Ms. Donohue could not have seen the snail in the beverage prior to drinking. The only way she knew that it was there was it came into contact with her lips. So she tries to bring in action. Now the question is, who does she sue?
Yeah.
Who's the defendant in this case?
The manufacturer.
Okay. But this is a time when we have contract dominating all relationships. We haven't yet recognized tort, at least in the negligence sense. So Ms. Donohue says, well, the beverage was bought from the store owner, Stevenson. So I'm going to sue him. And even though I don't have a contract, we're bound in some way. I bought the drink from him. The difficulty is what for Ms. Donohue?
You didn't modify anything.
Yeah, he purchased the beverage, likely as part of a crate that was delivered to him, probably from the manufacturer. So he had no handling of the product in terms of its packaging. All he did was take it out and serve it. So Ms. Donohue can't sue Stevenson. She has to sue the manufacturer. But what's the problem there?
There's no contract between them.
Right, there's no privity. We do have a contract between the store owner and the manufacturer, but Ms. Donohue was not part of that contract. So what Ms. Donohue is coming to the House of Lords saying is, I have a problem that the court should be able to provide a remedy for. But she's also asking the court to recognize something that to that point had not been recognized, because everything was done through contracts. or quasi-contracts. Here, Ms. Donahue was looking for the court, the House of Lords, to impose an obligation on the manufacturer of a good. And at that point, 1930s England, that was unheard of. Now, we know it as a distinct area of law of product liability. The court, and particularly Lord Atkin,
Yes. Neighbor.
devised a way of providing Miss Donahue with a remedy. What did he start with?
Got it from the Bible.
The Bible.
Yeah.
Love your neighbor.
Yeah. Who's your neighbor?
Lord Atkin knew his Bible, looks back to it and says, well, hold on. We all have an obligation towards each other. That he called the neighbor principle. That was a reference to the Bible that says, treat your neighbor as you want to be treated yourself. And what's interesting, I think, is he basically brings in this Judeo-Christian principle into a landmark case of law. That's where this started. So what are the elements of this? Who is a neighbor?
Who's your coach?
So how did Atkin answer that?
It's regulating proximity for people that come within that scope of potentially or foreseeably being harmed.
Right. So those who could foreseeably be harmed by our actions. How does that translate to the manufacturer of ginger beer?
If you're producing a product that's going to go out to the public, potentially.
And?
So it is foreseeable that if you don't take proper precautions in terms of producing this product, that one of your consumers can be potentially harmed.
Right. So there we have Lord Acton establishing what has become the biggest area, I'd say, of tort law, negligence. Using the Bible and saying we have a duty to our neighbor, that is anybody who could be foreseeably harmed by our conduct. And within this particular case, a manufacturer has a duty to his or her neighbors to take proper care in the manufacturing of their goods so as not to harm consumers or, using Atkin's language, its neighbors. Now, arguably, that's a quite broad test. A duty of care is recognized when you have this idea of your actions foreseeably harming somebody within your scope of contact. If we think about that today, that could be a very broad range of people. And something we'll see as we go through negligence is that the common law is particularly, and I started the course with this, particularly concerned with the concept of indeterminacy. Indeterminacy, again, means the courts do not want to create a precedent where liability could be indeterminate. There's not a defined class of people that could be, in this case, like Miss Donahue. So indeterminacy in Donahue was not a problem because it was only people who would be harmed by the manufacturer of the ginger beer. It wouldn't be everyone. But as you go through time, that argument could be expanded. And I say this because that sets up what happens in 1977 with the case of Anne's Merton. By this time, about 40 years later, the House of Lords is concerned with the way the test for duty of care has been handled and seeks to renovate it. And it devises what we now call the ANDS test, which I've outlined for you in the notes. Is it reasonably foreseeable that somebody would have been harmed by the impugned activity? Second, is there a policy reason that it would be inappropriate for a remedy to be awarded? So the first aspect we recognize from Donahue and Stevenson. It is that foreseeability of harm. But the second part of ANDS, is there a public policy reason to say there shouldn't be a duty of care recognized here? That's new. And arguably, that's quite broad. A lot could fit under that second heading. Now, the reason I'm going through the UK cases is that that has influenced Canadian tort law. If we were focusing only on Canadian tort law, I would stop right there and say the ANDS test is where Canada picks up and continues. But that is not quite accurate. So that's why I carry on with the English case of Caparo. Caparo versus Dickman, the House of Lords devises a new test for the duty of care. It is dissatisfied with the ANDS test. By 1990, the House of Lords is concerned with the expansion of tort litigation and seeks to rein it in. By devising the Caparo test, that it thinks will be more discreet in terms of narrowing the scope of tort liability. And by 1991, in Murphy and Brentwood, ANDS is dead in the UK.
But not in Canada.
Not in Canada. It survived the trek over the Atlantic. To put the overruling in context, by my last understanding, the House of Lords in its centuries of existence has only overruled itself 8 times. You can call that a positive or a negative.
Negative.
Stubborn or consistent. I'll leave that to you. But it's monumental when the House of Lords, now Supreme Court, says that decision we made long ago that none of us were part of, that's no longer the law. So Caparo is a big moment where the court says, here's the new test, which I outlined for you in the notes. But I think it's worth looking at the facts of this case because it helps us understand some of the distinctions that we will see with Canadian cases. So I'm going to be very simplistic about this, about the facts. Caparo was a shareholder in Company 1. Dickman was the auditor. Under company law, companies have to be audited each year. So Dickman was charged with doing that. Dickman presented his report and said, everything is good with Company 1. Based on that assessment, Caparo said, this might be a good opportunity to buy a company, to buy this company. It seems to be running pretty well. So based solely on Dickman's report, Caparo purchases Company 1. after purchasing Company One, they see a reality that was not spoken to in Dickman's report. The company is not in very good state. So they sue Dickman. And they say, you didn't take the proper care in providing your report on Company One, and you caused us this loss. The loss being the difference between what Company One should have been valued at and what they bought it for. And the House of Lords says, Caparo wins and loses. But there are 2 questions it's answering there. And the separation between whether Caparo wins or loses depends on what status Caparo is standing in. Caparo, as a shareholder of Company One, is owed a duty of care by Dickman. Why? Because there's a contractual relationship there. He didn't breach the contract, Dickman, because he provided the report. But he was careless or negligent in providing that report. And that's where we have the tort action. So Caparo, as a shareholder of Company One, has a duty of, is owed a duty of care by Dickman. But Caparo, as a potential purchaser of Company One, is not owed a duty of care by Dickman. Why would the House of Lords make that distinction? The same party, but standing in 2 very different situations. Any thoughts?
There was no contract when he made the report, right? There was no such a purchase when he made the report, right?
No, they purchased based on his report.
Yes, but the purchase came after that, so he couldn't, it's not foreseeable for him that expressly purchased the company.
Okay. So that's part of it. Deborah?
Yeah, but there's no enough proximity between like Dickman and the future buyer.
Okay.
It could be anyone.
Well, why couldn't it be Caparo? Why, in this case, Dickman gave the report to Caparo as a shareholder. Why couldn't Caparo use that to buy Company One?
In an audit report, the standard is the report is to the directors of the company rather than the shareholders per se. Also, there was an exclusion clause in all audit reports.
Yeah.
So the shareholder has one capacity. Once you produce the report, that's sufficient in terms of your duty to the shareholder.
Yeah.
To produce an accurate or unqualified report is a duty to the directors, not to the shareholder.
But the House of Lords went a bit further than that. You have your hand up. If you want to say.
So, as a visible purchaser, you're not supposed to only look at the audit report. You're supposed to, that's one of the tools. You're supposed to do your due diligence.
Yeah.
So, it's not reasonable to put all the blame on the audit.
And why isn't it? So going back to Lars' point, Dickman prepares the report for this discrete purpose. I'm going to audit the company. The House of Lords says, well, if Dickman was only hired for that purpose, we cannot hold him liable for anything beyond that purpose. So Caparo, using the report to buy Company One, is conduct beyond the purpose for which Dickman's report was provided. So that is why Caparo, in one status, can be owed a duty of care, but as a potential purchaser of the company, is not owed a duty of care. The report was not provided for that purpose. Building on the point that was made, I think we can kind of infer Caparo was being a bit cheap on this. Caparo really should have purchased advice on the company before purchasing it, and not rely solely on the audit report by Dickman. So let's think about the precedent that sets. If the House of Lords had found Dickman liable to Caparo as a potential purchaser, what effect would that have? Well, think about a law firm website. Law firms will talk about recent cases and say, you better look out for this or that, and provide a bit of advice, but they'll have a disclaimer at the end that says this isn't legal advice. If Caparo was decided the other way, arguably, people that relied upon what a law firm put on its website, acted upon that, could sue the firm. Even though that wasn't the purpose for which the material was put there. So the House of Lords is trying to restrict the scope of the duty of care for the purposes of restricting negligence litigation overall. And they make this distinction for that reason.
It's one of the principles of critical thinking. You know, when you read whatever paper,
Yeah.
you know who made it, for what purpose made it, right? I mean,
Yeah.
it's a critical thinking. If something was made for one purpose,
Yeah.
it cannot be used, or it has to be critically used for another purpose.
Keep that in mind for the last week. We'll come to a case that I think challenges this from Canada, the Supreme Court. So Caparo is simple. We'll see a more complicated fact scenario. But what we take from it now is that not only has the House of Lords renovated the duty of care test to this three-part test of reasonable foreseeability, proximity, and whether it's fair, just, and reasonable to find the duty of care, but they've also made a critical distinction here in terms of an area that we all care deeply about, providing professional advice. You can only be sued for the purpose for which your advice was given, not beyond that. Now, I've mentioned Caparo because that's the route that the House of Lords, now Supreme Court, has taken. It remained available to the Canadian Supreme Court to follow Caparo, but it hasn't. It's maintained the ANDS test. And so under the heading ANDS test in Canada, in your notes, the Supreme Court renovated the test in Kamloops. So we now call it the ANDS Kamloops test, denoting the two cases. Is there sufficiently close proximity between the parties so that the reasonable contemplation of the defendant carelessness on its part might cause damage to the plaintiff? If so, are there any considerations which ought to negative or limit the scope of the duty, the class of persons to whom it is owed, the damages to which a breach of it may give rise? So the policy consideration in ANDS test, that second question, remains in Canada. But the Supreme Court didn't leave the test alone at that. In 2001, in a case called Cooper versus Hobart, the Supreme Court made a distinction. That distinction is the ANDS Kamloops test is used in certain circumstances. Those circumstances are where there's an established duty of care. That phrase means that the courts have already recognized that in this relationship, for example, doctor and patient, doctors owe patients a duty of care. So in those circumstances, you use the Aug6 test. But if you're coming to the court and asking for the court to recognize a novel duty of care, a new area in which a duty of care is recognized, for example, naturopathic doctors and patients, let's say, are they like doctors or not? If they're not, if that's a novel duty of care, you're supposed to use the Aug6 test, which I've outlined for you. But under the heading, establishing a duty of care, established category, or a novel duty of care, I've tried to outline for you how to approach duty of care in Canada. So the first question, as a preliminary matter, is the alleged duty of care within an established category or analogous to an established category? Again, my example was doctor-patient. If the case alleges a novel duty of care, was the harm reasonably foreseeable? So Aug6, Aug6 or Aug6, the first question is this a recognized duty of care, an established duty of care? If it isn't, if it is not an established duty of care, that is, the plaintiff is seeking a novel duty of care to be recognized, then we proceed to, if the case alleges a novel duty of care, was the harm reasonably foreseeable? If it is an established duty of care, we just use the Aug6 test. So proceeding along with the Aug6, looking at C in the notes, even if the harm was foreseeable, was there a sufficient relationship of proximity between the parties to make it just and fair to impose a duty of care on the defendant? D, if there was foreseeable harm and a sufficient relationship of proximity, a prima facie duty exists. So, I hope the final part helps crystallize this. So I have duty of care, and then I have 5 points, just looking at the notes. Was it reasonably foreseeable that this plaintiff would be harmed? Was there proximity between plaintiff and defendant? If we're using Cooper, we ask, does the duty being put forward fit into an already recognized category? If it doesn't, we apply Cooper. And then there's a policy question. So, let's see. So go up to the Cooper, Hope, and Hobart case. And in the summary of the case that I've given you, there is a bolded item saying, test for a duty of care in a novel fact situation. 1A, 1B, and then 2. This is the Aug6 test. This test has 2 layers of public policy consideration. The Aug6 test has 1, the second question. That is basically the key difference. There are 2 layers of public policy analysis in Aug6. Aug6 has 1. So focusing on Aug6, we have the 1A aspect, which dates back to 1932, reasonable foreseeability. 1B, proximity. is there proximity between the parties? And this includes a public policy question. The first one, that asks, should the court recognize a duty of care between these two parties? In my novel example, a naturopathic doctor and a patient. So the court is asked, generally speaking, between a naturopathic doctor and a patient, should we recognize a duty of care? Even if there is proximity between these two people, one being a naturopathic doctor and one that is his or her patient. The court is stepping back and saying, is there a problem with recognizing a duty of care in this kind of relationship? Then the question goes to the second part, another public policy question, which basically asks, is there another reason to negatize or not recognize a duty of care in this situation? So it's not asking about the particularities of who the defendant and plaintiff are, naturopathic doctor and patient, but is there something else about this circumstance that says we the court, should not recognize a new duty of care in this circumstance?
I don't understand the difference.
Sorry?
I don't understand the difference. What the second policy question actually adds.
So it's saying, even if in 1B we think there's no public policy reason not to recognize a duty of care between a naturopathic doctor and a patient, aside from that, are there other considerations? So, using the UK as an example, we talked a bit about police. And in the UK last time, the police generally are not found to be liable. So the court may say, well, we think that police and victims of crime, there's nothing wrong abstractly in recognizing a duty of care between those two. But when we get to thinking about it beyond that relationship, we don't want to recognize a duty of care because we don't want the police to practice defensive policing. Like I said, it often occurs in the UK. That's used as a justification for not recognizing.
So the first policy is relationship?
Yep, and then the second
maybe
is
general,
more broad.
Yeah, with the society in general.
Yeah.
Just one concern here that is related to the recognition of the duty of care. The recognition of the duty of care should be in the first place, because if there is no duty of care, if the person doesn't owe a duty of care to the other, there is no negligence from the first place.
Right. I don't understand what you're asking.
Yeah. The recognition of the duty of care should be treated first, because of
I said that. Maybe I started before you come in. The first stage is the duty of care. Then we proceed to the breach, causation, remoteness. The duty of care is the most important, because without a duty of care, you can't establish the others, which I think is what you're saying.
Yes, but here we're talking about the duty of care in the policy reasons.
Yeah.
The second step.
Yeah.
And it should be treated from the beginning, because if we stop, a person doesn't owe a duty of care to the other, there is no negligence from the first step.
Yeah, but what the court is trying to do is say that the idea of owing a duty of care can be separated into two categories. One, the relationship between these two types of parties, doctor-patient. But then the court is trying to say there may be further circumstances that bear on this that tell us we should not recognize a duty of care in this circumstance. So the court is saying we're going to use the legacy of duty of care first, say whether or not there is something here. And then we're going to step back and consider the issue more broadly. Are there other considerations that tell us we shouldn't go this route? So let me put it to you in this perspective. As a plaintiff or a defendant, how do you deal with this test?
Yeah, I think it is the first element of the test, it is foreseeability and proximity. And the second element of the test, it is the policy reasons.
But proximity also has a policy consideration. So if we have a case where a victim of crime is suing the police, we can say it is reasonably foreseeable that if the police are careless in how they conduct themselves, this will lead to harm to this person. Then we go to proximity. Legally, we see proximity, but we ask the question on a policy level. Should we recognize a duty of care between the police and a victim of crime? We ask that, we debate it. What the court expects at that time, I would suggest, and why I ask the question is, the plaintiff will make arguments for why it should be recognized. The defendant will make arguments for why it shouldn't be. So for our purposes on an exam, the same thing that I talked about in contract would apply. Somebody comes to you with a problem and asks, do I have a case? So you assess both sides of that fact scenario. What are the arguments, the competing arguments, for recognizing a duty of care between between the police and a victim of crime?
It means it's the burden of proof here.
No, not the burden of proof. The policy is about...
Yeah, I know about the policy reason, but the differences between Anis and Cooper together, it is related to who bears the burden of proof in order to prove the policy reasons itself.
Well, the burden of proof, it remains the same in negligence. It'll always be on the plaintiff to show why all elements are satisfied.
But the defendant is going to prove the policy reason.
The defendant, in my example of the police, they will make arguments for why a duty of care shouldn't be recognized in this instance.
Yeah, it means that from the first one, the plaintiff bears the burden of proof, and for the second element itself, the defendant bears the burden of proof.
No. The defendant doesn't bear a burden of proof on this.
Relying on the public courts.
Sorry?
Relying on the public courts.
No, the court is assessing, is there a reason why? They ask themselves the question twice, but in two different situations. Is there a reason why we should not recognize a duty of care? The burden of proof is not on a defendant for that reason. The defendant does not need to prove anything. The defendant will make arguments. Theoretically, in a tort case, in a private law case, a defendant could make no arguments. But there's a concept called an adverse inference, where a court can say, well, you didn't say anything, so we assume that you just agreed, and we'll carry on. So a defendant will put forward their reasons why there shouldn't be a duty of care recognized on the public policy grounds, but not because there's a burden of proof. There's a strategic reason for it. You're not going to give up ground, basically. You're not going to let the other side only do the talking on something like this. But the question of policy, public policy, is at two different stages. The particularities of this relationship, and then stepping back beyond those particularities of the relationship are there other considerations that suggest to the court that a duty of care should not be recognized in this instance? Balcar?
So for this instance, for the first one, you can pretty much say that they also have then the police do owe a duty of care to the public. Then on the second one, we could say, well, for in terms of like statutory purpose or economically, there's limited resources, and that's the reason why you can't really protect.
Yeah, the broader public policy. So theoretically, you can have a situation, and we will find a case that does this, that 1A and 1B in Anne's Cooper is satisfied, but the Supreme Court says it fails on 2. Sorry, Tim.
Sorry, Cooper clearly demonstrated your point about if the court had ruled in favor of the plaintiff.
In Caparo.
Not in Caparo, I'm talking about Cooper.
Yeah.
Our case, Canadian case.
Okay.
Then it would have made the public made the public into an insurer for investors.
Yeah.
So that would go against public policy, and it's not a question of the defendant or the plaintiff arguing the point. It's a matter of the court taking the view.
Right, but my point is, if we think about it in exam circumstances, and I'm hoping this makes it clear, we're mimicking when somebody comes to you asking for legal advice. So if the question has 2 layers of public policy, you need to turn your attention to what will be the arguments at those stages of public policy. So we can say, sure, we should recognize, Balcar did it for us in terms of not recognizing it, duty of care against the police. But your assessment has to consider those factors, is the point I'm making here. Not that there's a burden of proof or anything like that. In order to give your advice, you have to objectively assess the criteria as applied to the facts. Yeah.
Can I ask, if we're dealing with a novel fact situation, how analyzing the established categories of negligence, how we would analyze the established categories of negligence, because presumably...
Why would you in a novel duty of care?
Well, that's what, it's your bullet point under 1D. Proximity, which includes questions of public policy. This is a specific policy question, and the full policy is a general question. Best way is to look at established categories of negligence.
Right. So that's in relation to, is there, so my preliminary question, as a preliminary matter, is the alleged duty of care within an established category or analogous to established categories?
Okay.
So if you have, in my example again, doctor-patient is an established category, could we say naturopathic doctor and patient is analogous? So in practice, what you do is you prepare for both. If you have the naturopathic doctor scenario, just as an example, you prepare for it as an established or analogous, established analogous, or as a novel duty of care. For exam purposes, I will tell you which one.
In B, you say that according to Childs versus the Zormont, really density to bear tendencies to the defendant to raise any medical considerations.
So if the defendant is using the police have an obligation to show, to say not just there shouldn't be a duty of care recognized, but why? What backs up your argument? So my example again of the UK police, they'll say, well, money is being diverted from police services to paying for these tort claims. And that is not in the public interest.
So the burden shifts to the defendant, so the last element is.
What it's saying, not the burden of proof. The defendant has to establish through evidence that supports its argument. So what it's trying to say in trials is, it's not good enough for the police in our scenario to say,
Just bring them up.
to just say no. That's insufficient. What evidence do you have to show that a duty of care shouldn't be recognized based on public policy grounds? Yeah.
Can I ask a bit of an obtuse question about the reasonable, I guess it's under reasonable foreseeability, but the answer might impact the way one analyzes 1B and 2.
Okay.
But I'm thinking back to the first case as well.
Rankin's Garage.
Yes. How does one, I suppose, yes, there was a distinction, I think, in relation to what had to be foreseeable, whether it was just that somebody might steal the car and cause injury to somebody else, or that these young kids could steal it intoxicated and go on a joyride, etc.
Right.
That does kind of complicate the analysis a little bit.
A little, okay.
I think anyway, and I guess I'm asking.
So remember our discussion, let me just help you recall the Rankin's Garage case. That's the one where I keep thinking it's the mother that supplied it. Was it? With marijuana and alcohol? Okay. And then the two kids, her son and his friend, went off, stole a car, drove it recklessly, and then the passenger was severely brain damaged. If you recall in that, I talked about the majority and the minority opinions. So there's no dissent. Both said, sorry, no, there was a dissent, I got mixed up. The majority and the dissent, 5 of them said there shouldn't be a duty of care here. 4 said there should be. And the distinction was hard to pin down, if you recall, because I've suggested to you that the language was kind of loose in how the court explained itself, especially the majority. The majority, I think, was trying to say that it's not reasonably foreseeable, but too remote. And remoteness is this idea that there are too many, there's an improbable sequence of events that has to transpire in order for this to happen. But the majority called that reasonable foreseeability. And they mixed, in my opinion, brought in remoteness talk into the reasonable foreseeability. And if you recall, what I said at that time was, I think the Supreme Court was concerned about a scenario like this. You leave your car in your laneway with the keys in the ignition, unlocked. Somebody steals it, and the same sequence of events happen. If they find Rankin's Garage liable, then that individual has to be liable. And they don't think that that should be the case. That would be extending the duty of care too far. So what they said was, well, no, it wasn't reasonably foreseeable that 2 minors would become intoxicated and drive the car recklessly, resulting in injury to one of them. And the question I posed to you was, can you name to me one instance where a car was stolen and not driven recklessly? It's almost in the nature of it. And it was kind of poor reasoning, I would say. But generally, the court was trying to say, this is an instance that extends the duty of care too far. But I also said the dissent was accurate. If you apply the test as it is, that harm is reasonably foreseeable if you were careless, Rankins Garage, and the dissent said they were, then you satisfied the test. And what I explained to you at the time was, well, why the difference? And I said both are correct, but by a majority of one, the majority wins out, and they're trying to restrict how the duty of care test is applied. That's what it came down to, I think, in Rankins Garage. But it's not a very well-reasoned decision at the minority. Yeah.
I mean, just thinking, I just want to try to, and I'm sure we're going to get to it through more illustrations.
Yeah.
Is what you're saying that really using either proximity or the general policy question, perhaps, you can actually limit the duty of care. You would have been able to limit the duty of care in Rankin's Garage because, as the minority probably rightly says, it would have been reasonably foreseeable.
Yeah, the policy could have been used. The majority said it failed at 1A.
Yes, and that's a questionable conclusion.
Yeah, whereas the dissent says you don't use Anne's Cooper. You use Anne's Kamloops. This is an established duty of care.
Okay.
So they disagreed very much on how the law was applied in this case. What do we take from that? What I've suggested is that there's concern for how expansively the duty of care test is applied. There's concern about tort litigation becoming too big, something that we've seen already with the renovations of the test. And that even the Supreme Court can be guilty of being unclear and confusing. So I think Rankins Garage will continue to be a problem until the court clarifies its position. The reasoning of it, sorry.
I was going to say, in terms of like expanding that duty of care term, do you recall the Aug6 case from England?
In psychiatric distress in the UK.
It kind of reminds me of that case in terms of like the flooding argument that they raised into, like limiting who does that duty of care actually apply to.
Yeah, that was sort of a blunt version of it. We'll get to that, I think, next week. I think. Maybe tomorrow. I'm not sure. It's a mystery. But we will see that. Yeah.
Can I ask a question about whether there's any practical difference between the UK ruling Caparo test and the Canadian test, Cooper and Anson Cooper, whether there's any practical difference? Know that the three elements are seen that in both tests, but I mean, how when they apply, they make no difference.
I don't know if there's necessarily a difference. The UK Supreme Court in 2018, in a decision called Robinson, where the police were actually found liable, said basically what the Supreme Court does in Anne's Cooper, that there is an established duty of care class, and then there's a novel duty of care class. And the novel duty of care class, you use the Caparo test. If it's an established duty of care, you use the established test. So in that sense, you could say there isn't, but I guess I'm hesitant to say that they are the same, because if they were, I would have thought the Supreme Court of Canada at least would have said so. Yeah.
The Caparo case did not deal with public policy, did it?
Yeah.
In a direct way compared to
the third
Cooper.
stage. Would it be fair, just, and reasonable to find a duty of care in this instance?
It was not in the manner of Cooper in terms of
it hasn't separated it into the relationship and then a broader question. But I think the question was, are these two versions of a test that are similar, substantially similar? Was the way I understood the question. And I said, I refrain from saying that, although the Robinson case from 2018, I think, does go some way towards suggesting there's at least a spiritual overlap.
I just wonder if it's, for me, is it, if I reverse the whole thing and I'm saying simply when it's a novel issue, it's a novel duty of care, then obviously the question of policy, if it's against public policy, is more the question of the court, right? It's a novel thing. They
There are
never
two
discussed
layers.
it, so they will discuss it in 2 layers.
Yeah.
When it's not a new thing, then it was already discussed.
Yes, that's the thing.
So that's why they don't have to have 2 layers.
Yeah,
So
but
I
they
think
still
that's-
have the public
Yeah, they
policy.
still have
discussion.
the public policy, because public policy can change with
Yeah.
time. So it's normal that as a second part, they consider. I think that makes it easier for the others also.
Okay. Any other questions? So tomorrow, we start with duties of affirmative action, and then specific duties of care, I think.